Hey, Jim, are you there?
I'm here.
Okay, good. I'm sorry. I think I just popped out for 1 second.
Yeah, no
Okay.
problem.
I'm just gonna I'm just gonna click through to stream this on Facebook. We should be good.
Okay, sounds good.
Oh, setting up your Facebook Live. All right. Okay. Okay. Okay, so we are live now. So welcome, those of you listening on Facebook or watching on Facebook Live. My name is Brian Silvestry, and I'm a real estate broker in New York City. And my guest today is an attorney with approximately 3 decades of experience in private practice, dealing with wills and trusts, probate, probate of estates, estate planning, guardianship, and also just general residential and commercial real estate processes. So we're going to be discussing a little bit um, some aspects of probate today. So welcome, James Striar, to the Facebook Live. Thank you for being here.
Thank you for having me, Brian. I really appreciate you putting this all together and look forward to speaking with whoever's on. I hope everybody is healthy and adapting and adjusting to this time as well as possible. But thank you for having me.
Yes, our pleasure. Thank you for taking the time to join us. So we could jump right in. So the first question that I wanted to ask is just in general, a lot of people ask questions about wills. And maybe you can just give us a little information as to what should be included in a will and anything that, or what things that you normally see that are often missing in a will.
Sure. So, a lot of times people delay making a will for a variety of reasons, but eventually, hopefully, you get around to it at whatever stage in life that you're at, whether you're single, you're getting married, you have children. So, as far as the will itself, obviously, you want to have a very clear idea of how you want your assets to go, who you want them to go to. Um, Obviously, most of the time it's spouse to spouse, and then if not, then to the children or some combination of. Um, Everybody's situation is different at whatever stage in life they're at. So, you want to be as clear as possible, think it out as well as possible, whether, you're speaking to your attorney, your spouse. Um, you're going to have to name an executor, the person who you're putting in charge of handling the estate. So generally, that person is going to be somebody that you trust. Most of the times, it's a spouse. If there is no spouse, a sibling, somebody who's of similar age, or possibly even a little younger, depending on the age of the person making the will. Uh, Generally, you don't necessarily want to have somebody much older than you be the executor, uh, for just age reasons, lifespan. And you're going to want to name an alternate executor as well, just in case the person that you appoint isn't around or isn't able to serve as the fiduciary. Some people want to have co-executors. Maybe they have brother and sister and they don't want to choose, or maybe, choose one over the other. Maybe one sibling lives far away and the other lives close. So there might be practical reasons to only choose one over both, but oftentimes for sentimental reasons or not wanting to hurt somebody's feelings, people will choose co-executors. But there's pros and cons to each of those. So once you've allocated who you want your assets to go to, how much to each party or person. Some people obviously leave to charities or foundations. You want to have your executor, and if there's anything specific, whether it's a piece of property, real estate, whether it's a particular brokerage account or bank account, or jewelry, you want, that's going to be laid out in the will specifically, so there's no confusion or there's no arguing after the fact.
Okay. And what things do you usually see that, might be left out of a will, or what do you ever see any cases where a will was maybe prepared by someone other than yourself that, doesn't specialize in this area of practice, and maybe leads to issues later?
Sure. I think a couple of things. One is that somebody may forget to name a specific bank account if they wanted to go to one particular person, and obviously if that account doesn't already have a designated beneficiary on it. Probably the wills that I see that haven't been necessarily prepared by an attorney are the online wills. It could be LegalZoom, a variety of different online platforms that are, we'll call it, fairly generic. They definitely fit for certain situations where it's a very basic will, but sometimes they can lead to more issues or possibility of a will contest if they haven't been comprehensively completed. And then also the execution of the will under, New York state law, the will has to be witnessed by two people, and there's a very specific protocol that has to be met in order for the will to be probatable in surrogate's court after the person passes away.
Okay, it's interesting. And just as a side, like, how often do you see people that come to you and they're coming to probate an estate and there was no will?
I see that a lot. It's probably more often that there is not a will than there is a will. So in New York State, if there is a will, you go through the process which is called probate. If there is no will, then the person is deemed to have passed away intestate, and you go through a very similar process, but it's called administration. So in that case, one family member, and there's a sort of priority, it goes, the assets will pass to the spouse. If there's children and a spouse, it goes 50% to the spouse, 50% to the children. If there's no spouse and no children, it goes to the parents. If no parents, then it goes to the siblings, if there are siblings, or nieces and nephews of predeceased siblings. So there's a whole family tree priority that you have to go through, and in different situations you have to get what's called jurisdiction over all of the interested parties who may be participating in the estate. I've had estates where there's no will, so we go through administration, and there's 28 cousins, and we have to get jurisdiction, meaning serve all 28 people with what's called a court citation, to even begin the process of administering the estate, just to get somebody appointed. And that can become quite a lengthy, proceeding. And sometimes you have family that's overseas, international. So you have to then get jurisdiction over them. So in an ideal world, having a will that lays out, who you want your assets to go to, how you want them to go, and who's going to be the person that you're appointing in charge of the estate would be the ideal situation.
Okay. Okay. Yeah, it's interesting because a few years ago, maybe about 2 years ago, I had a client, and he was in his mid-70s, had just had a stroke, and he was considering selling a townhouse that he had in Harlem. So we met one afternoon to go to lunch, and I just, thought to ask him. I said, "Hey, by the way, I know he doesn't have any children. So if something happened to you, what would you want to happen to the house?" And he said, "Well, I guess I would give it to my sisters." And I said, "Just, out of curiosity, any chance you have anything written down in those terms?" And he looked at me and he said, "Why, you worried I'm going to die?" And I said to him, "Well, you just had a stroke."
Right.
So, I even as a real estate broker, I do sometimes ask those questions because, we want our clients to be taken care of. And a lot of times I get more, I do get those type of answers. So the next question I want to ask is about trusts. And can you talk a little bit about trust and who should have, and, what's the advantages or if any disadvantages?
Sure. So there's really two types of trust. There's a revocable trust and an irrevocable trust. So with an irrevocable trust, just like it sounds, once you make the trust and transfer your assets to it, you can't undo it, because the reason for the irrevocable component of it is when you pass away, the assets that are in the trust are outside of your ownership. The IRS calls it incidents of ownership.
Mm-hmm.
So those are not in your estate anymore, and they can't be taxable. If you have a revocable trust, you still have control over those assets. So they would be taxable if your estate or your assets rises to a high enough level that they would be in a state tax bracket for the federal or for New York State. Some people want to transfer their assets to a trust to avoid probate. So we just spent time talking about some of the parts of the probate process, which can be it can take a good amount of time. Sometimes there can be uncertainty. You could, in a probate or will situation, you could have a family member that chooses to contest the will, which can create uncertainty, time, additional fees. So, and also a probate or administration is a public record. And anything filed with the court is a public record. And some people would prefer not to have all of that information about their assets, their family, in the public forum. So people choose to do a trust, whether it's a revocable or irrevocable. One of the important parts of establishing a trust is making sure that once the trust document, which is the papers that establish the trust, you then actually have to transfer title to your assets that you're putting in the trust. Sometimes you'll see somebody set up a trust through an attorney, but they don't fund the trust. They don't actually do the second part of it to actually retitle the assets into the name of the trust. and that can become an issue down the road. And then the third part of it is you just have to realize when you're setting up a trust, revocable or irrevocable, and you transfer those assets to the trust, that any further decisions or management of those assets has to be through the trust, through the trustee that you establish. And as we talked about with picking an executor on a will, you have to go through the same process in naming a trustee or co-trustees or an alternate trustee.
Okay. And other than, what would you say the advantage or disadvantages of irrevocable and a revocable trust would be? Other than for irrevocable, as you said, you can't change it, you can't revoke it.
Right. Well, the advantage for an irrevocable is it's completely outside of your estate for estate tax purposes. Some people then it can morph into Medicaid planning and getting assets out of your name that way. But the key component for the irrevocable trust is to have it completely outside of your estate for estate tax purposes. If it's revocable, you still have control. You can still tweak it, as time goes on. And just to jump back to the will, it's that we were talking about. Once you make the will, obviously the will is not set in stone. As time goes on, and as your life changes or your assets change or your family changes, you can make either a new will or you can make a codicil, which is, a smaller version of, it's basically an amendment or a change to the will. So those documents are not set in stone once you execute them, because life changes and everybody's situation changes. Your kids get older and you may want to change those either beneficiaries or amounts. Sometimes you have younger kids like Brian. You have triplets who are very young, and if you had a will, you might want to establish a trust within the will, which is called a testamentary trust. And at this point, you might say, I want to have my kids receive some of that money at age 25 and half at 30. But as time goes on and you see, well, this kid is really responsible, or maybe this one isn't as responsible, you might have to tweak that a little. So the nice thing about the documents is, other than the irrevocable trust, the other documents are not set in stone, and you can change and adapt them as you need to as time goes on.
Okay, thank you. And as far as the difference between someone having a trust or just, probating a will, other than the fact that, the probate process is part of the public record, as you said, so anyone can look up that information. What other advantages are there to having a trust versus just going through the whole probate process? Is it more, costly, for example?
Well, the cost part, we'll put the cost part on aside for a second.
Mm-hmm.
If you have a trust and you've established a trust and you transferred all the assets to the trust, once a person passes away, the assets are already in the trust to distribute as per whatever the instructions or the allocation is in the trust. So it's a much faster, more expedient process. It's much more efficient. If you have to go through a will, or if there's no will and you're going through an administration through the surrogate's court, it can be a time-consuming process. So certainly there's a benefit of time with having a trust. As far as the cost to do a will is usually less than to establish a trust. However, the cost to administer or probate the estate through surrogate's court, whether a will or no will, is going to normally far exceed the cost of setting up a trust. So there's a benefit, a cost benefit, pros and cons to each side. Some people aren't comfortable transferring all their assets to a trust and basically having the trust own and operate everything, and they still want to have total control of their assets while they're alive. So each person's different, each person's situation is different, and it's just important for each person to have a sit down or a Zoom face-to-face with their attorney and discuss their particular specific situation.
Okay. And what about the probate process in general? What pre-pandemic was it like as far as timing and the different steps, and what do you anticipate going forward it's going to be like?
Sure. So pre-pandemic, the process is basically if there are no issues, we'll call it. There's a filing of a petition with the surrogates court, which gets reviewed. It usually takes a couple of weeks to a month, depending on the county. Some counties are quicker. New York City currently does not have e-filing for surrogates court, which causes some time delays. A lot of other counties, Westchester, Rockland, Nassau, Suffolk, they do have e-filing, so things are a little more streamlined. So part of the, once the petition is filed and reviewed, if there's a will, you have to provide some additional documents, affidavits from the attesting witnesses. So there's a whole, sort of a number of pieces to the puzzle that have to be in place. You may have to get something called waivers and consents from interested parties that they consent to the will and the appointment of the named executor. So it's hard to put an exact, sort of generic, hey, this is how much time it takes. It really runs the gamut on the particular situation, the particular court, the time of year. In the summer, there's usually only one calendar day a month. So there's some practical parts of it which can cause additional time. But if there's a will contest, well, that's going to take a long time. That could easily take a year plus. So it can become very time consuming. Now, here we are, the courts have been closed for 2 months. They haven't been accepting any new petitions. By and large, you can mail it in and wait for it to be reviewed, but it's a bit of an unknown how long it's going to take. I imagine, I'd love to be optimistic and say things will run smoothly, but even when things are running smoothly in the courts, it often takes much longer than we would all like. So it's kind of a wait and see.
Okay. So, because what I've seen from some of my clients, and tell me if this is like more or less what your experience is that they when they apply to become executor or administrator, they normally on average wait like somewhere around 2 to 3 months. Is that more, pre-pandemic, what you were seeing as well in New York City?
I think it's right around there. It all depends on whether you have all your documents in place, affidavits signed, and like I said, some counties are run more efficiently than others, but 2 to 3 months is not an unreasonable figure. I'll point out, when there is no will, oftentimes the court will require that the administrator post a bond. And getting a bond sometimes is problematic for some people based on what their credit level is, because that's how the surety company or the bond company approves or disapproves a bond. The court requires a bond for two situations. One, they want to make sure that the fiduciary doesn't run off with the money and not distribute it as it's supposed to be and to who it's supposed to be distributed. And also, in the event there are any creditors that file a claim, and that's a proper claim of money that's supposed to be paid to that entity. So if there is no will and we have to go through an administration, making sure that the person who petitions the court is bondable is an important component to figure out at the beginning, not after the court has appointed them and now they can't get a bond and we have to start the process over. So the timing, like I said, I'd love to give you a cookie cutter, here's how long it takes, but each situation is really different.
Interesting, because recently I had a transaction where just at the very end, they found out that the seller needed to get a bond, and
Right.
so we were almost ready to close the property, and the court required a bond, so he had to. It was added another step to the process.
Yeah, I'll throw one more wrinkle out there. In an
Mhm.
administration, the court, if there's real property that's owned in the estate,
Mhm.
the court will normally limit the letters of administration. They'll put a restriction on, which says, it's called SCPA 8053, that says that the real estate can't be sold without court approval. So somebody files a petition, gets appointed as the administrator, posts the bond, and then there's a property that has to be sold. The real estate broker finds a buyer. We enter into a contract. We then have to file a petition to the court to get approval to sell it. We have to include a written appraisal from a licensed appraiser, along with the contract of sale, to prove to the court that the administrator isn't selling the property for, less or far less than the property is worth, which would negatively impact the beneficiaries. So there's that component of it as well when real estate is involved.
So, and when real estate is involved, at what point is the person allowed to put a property up for sale? Because, correct me if I'm wrong, but for a lot of people, the biggest asset of the estate, or in a lot of cases, the majority of the value of the estate might be coming from a property. So, when a person passes away and now they have a property that's sitting there empty, if it's an apartment or a house, they're going to be paying monthly maintenance, taxes, and so they have a significant carrying cost. So at what point in the process can they go ahead and find a broker and start that process of selling?
Sure. I mean, the sort of simple answer is, once they're appointed by the court, meaning the court has issued a decree and issued either letters testamentary if there's a will, or letters of administration if there is no will and we're going through intestacy and administration proceeding.
Mm-hmm.
So once those letters have been appointed, then the fiduciary, has the authority to enter into a listing agreement with the brokerage company, enter into a contract of sale. But you're right, oftentimes the real estate is not only the largest asset in the estate, sometimes it's really the only one. And that creates, cash flow issues to be able to pay for things, real estate taxes, insurance, along the way. And you have this, bump up against the court timing, where the timing takes a while. And here, let's throw in, oh, by the way, there's a pandemic and now the courts are closed. So it can become an issue. There are situations where you can apply for preliminary letters to try to sort of expedite that part of the process. You have to establish to the court the reason for it, because otherwise everybody would just apply for preliminary letters. You have to provide an affidavit, to establish the reason why it's needed, because obviously you don't want to jeopardize the asset of the estate, which is then going to harm the beneficiaries.
Okay, thank you. And yeah, it was interesting because I remember once having a client actually that I'd come across, and they had a house that was just sitting vacant. And I asked them, why do you have this house sitting vacant? And they said, well, the estate is all tangled up. So the women that were going to be selling it, so they were, let's say, in their 40s or 50, and their father was the executor of the estate, and he had passed away, like, let's say 20 years ago or so. And when they were little girls, that's when he was the executor of the estate, never probated it, just left it alone. And then now he died without a will, and then now it was theirs. And there was many children there was children in different countries, in the Caribbean and all over the place. And they just looked at it like it was a big hornet's nest that there was no way for them to untangle.
Yeah, I'm curious what they ended up doing with it. I mean, sometimes properties in those situations can end up in a tax lien foreclosure if nobody's paying the taxes. Hopefully there wasn't a mortgage on the property, because then nobody's paying the mortgage. So yeah, I do see a lot of, we'll call it family properties, where grandma or grandpa or mom or dad have passed away many years ago, and nobody took the time to handle things then, or transfer the deed to the property, if they were able to, through intestacy. And you get a lot of situations like that, where sometimes you have to do multiple estates for one property in order to have the authority to sell it. So certainly I would recommend, when that happens and somebody passes away in the family, that somebody steps up to, take control of that particular asset and deal with it then, because the longer you wait, the harder it gets, obviously.
Absolutely. Well, what they wound up doing is they had an investor that approached them, offering 70 cents on the dollar,
Sure.
and for a closing that would take place in about a week. And their perception was that if they can take this offer, this cash offer, and be done with it, or they could try to untangle this and have to go and search for people and so on and so forth. So, they wound up going ahead and closing with this investor. But in that case, the money that they got, they still had to deal with it anyway, didn't they?
Well,
in other words, yeah, I'm sorry, go ahead.
Yeah, no, I was going to say, if they sold it, assuming one of them had been appointed as the administrator, the money would, whatever the net proceeds were, would get distributed, to 3 ways, 8 ways, 12 ways, whatever it's going to be. But they would still have to go through that process of making sure they had jurisdiction over all interested parties. But yeah, I receive calls from, real estate investors who mine the surrogates court for estates. And, they offer to buy it quick at a discount, just to take the headache off the hands of the estate. And sometimes there's a valid reason for family to do that, if there's multiple issues going on. Like I said, I have this one estate where there's 28 interested parties, distributees, so a property in Brooklyn, and once you divide it up 28 ways or however many ways it's going to get divided up, it's may not be worth everybody's time to wait until everything is done, and you may just want to get what you can and move on. So yeah, a lot of the real estate investors will look to make it quick and easy, and sometimes it's to a benefit. You want to speak to your client and give them the pros and cons of each situation, and help them make the best decision.
Yes. And I'll just add this as we're starting to wrap up here. If anyone that's watching on Facebook Live has any question that they'd like to ask, please go ahead and you can send that in the comments box, and we could ask Jim a question or two. So I actually had a client that I wound up selling an apartment for them downtown I think it was about 3 years ago. And they're still waiting for the funds, because even though there was a very ironclad will, what happened was there someone in their family, the brother or the mother, there was a rift in the family. They decided to sue. And so now the apartment is sold and closed. It's sold and closed 3 years ago, probably. And unfortunately, little by little, what's happening is that the proceeds are getting willed down.
Right. Yeah, no, I've seen that situation. At any point in an estate, there's sort of a business decision to make as far as whether somebody is going to contest or not. And if somebody contests, is it worth it to try to resolve that early on, to eliminate the time that a will contest takes, to eliminate the uncertainty that it can cause, uncertainty of the outcome, and to eliminate the costs involved with litigating a will contest or defending a will contest. Unfortunately, a lot of times you're dealing with family, you're dealing with emotions, and sometimes when it's time to make sort of a good business decision based on the amount of money involved and the possible outcomes, people are emotional, and they may not be able to make a clear business decision, and they get stubborn.
Yeah, absolutely. Yeah. So from Facebook Live, we just want to make sure to thank our guest, James Striar. He's a real estate attorney that his practice includes what we've been talking about: probating of states, trusts, and also what other aspects of did your practice cover?
Well, it really runs the gamut of anything dealing with trust and estates, surrogates court, so estate planning, wills, trusts, guardianship proceedings. I just want to mention one other thing is when somebody looks to go to do their will, they should also look to complete and execute 3 other documents: a healthcare proxy, a power of attorney, and a living will. Obviously, with all the medical issues going on now, having a healthcare proxy where you appoint someone to be able to make medical decisions for you if you're unable to is very important. Having a durable power of attorney is important as well, either in the situation where you have to go out of state, out of country, and there's documents that need to be signed. You can appoint somebody that you trust to be able to execute those documents, or, God forbid, you become incompetent. If you've already executed a power of attorney prior to that happening, the attorney, the agent, the person that you appoint can act on your behalf. If not, you may have to, a family member may have to commence a guardianship proceeding, which is a whole nother Facebook Live session to go through that. But these
We'll
are
cover
simple,
that on a future Facebook
yeah,
Live.
these are simple documents that can be and should be executed by everybody, basically 18 and over. In fact, when my children turned 18, I had them execute the documents as they were going off to college. And then I started doing it for a lot of friends' children as well, who were friends of my children. And I ended up getting asked so much about it that I set up a website which has all 50 state documents, because kids are in different colleges in different states, and different states have different rules.
Mm-hmm.
So there is a website. It's called kinfo.us, and it's very easy to access the documents. Data populate it, print them out, have it executed. So if people want to take a look at that.
How do you spell that?
It's
Kinfo.
Kinfo, KINFO.US.
Okay.
So it's like kinformation, information
Okay.
about your kin. We call it Kinfo.
Mm-hmm.
And it's been nice because it gives parents and your newly adult 18-year-old, 19-year-old, 20-year-old who are still feel like kids to the parents, but they're legal, obviously, in the eyes of the law. You want to have these, documents in place. God forbid something unfortunate happens.
Okay. And James, how do people reach you if they, have questions for you or want to use your services? And by the way, I just also want to mention that I was originally introduced to James Striar by another real estate agent who had been using James for many, many years, and she was singing his praises and said that he's the best attorney that she's ever dealt with, and she was using him personally. So he really knows what he's doing. If you need his service.
Well, thank you for that. I appreciate it. A lot of good attorneys out there. So, but I appreciate the nice words. My office is in Westchester County in Purchase, New York. My telephone number is 914-313-5280. My email is JG as in good, S, lawyer@AOL.com. I'm one of the, I'm holding on to the AOL for as long as I
can. No problem. And I'll put that in the notes on the video. And so when we distribute it out to different places, that we'll make sure and have that posted. So all your contact information.
I appreciate it, and thank you very much, Brian. I really appreciate you including me in this, and I wish good health and safety for everybody. Thank you very much.
Yeah, thank you. It's been great having you on, and thanks for taking some time out, and we really appreciate all the information, and maybe we'll get into some of those other topics on a future Facebook.
That would be nice. Thank you.
Thanks again, Jim. Okay, take care.
Be well.
Bye-bye. Okay. Thank you, everybody, for joining the Facebook Live. And any questions, feel free to ask. And I look forward to seeing you tomorrow when I have Philip Bornstein here. He's also a real estate attorney, but he's going to be talking more about what he's seeing as far as activity right now during the pandemic for transactions, as well as any changes in contracts that we're seeing now because of the pandemic or future concerns. All right, so everybody stay safe, and thanks again for joining. See you soon.